Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Recato of Recato Law, a small, apparently very significant law firm in central Minnesota. Because, boy, are there some people really putting a lot of stock into just how important my law firm is. It's very interesting, isn't it? It's so strange because I'm just a nobody attorney having a little fun on the internet, talking about stuff to my friends, to my fans, to whoever wants to listen. And then there it is, right? Suddenly, I go from being just a no importance attorney that no one has ever heard of or cared about, just fine by me, into being someone who, man, there's some very important attorneys that are out there that are really mad at me. All right. Okay. Have fun with it, I guess, guys. What do you do? What do you do? So, anyway, apparently, the small law firm in central Minnesota that is just important enough to devote all sorts of time and energy and narrative too. But that's the way it goes. That's the way it goes. And I guess, would you have it any other way? No, that's fine. So anyway, there's some fun things going on. Did I boomer this even harder than normal? I think I did. I got a letter today I wanted to talk to you guys about. You might find it funny. I don't know. I find these things kind of funny. I got a letter in the mail that is of interest, we'll say. We've got, of course, the Meyer versus Waid update that has happened. We've got Funimation's answer. I have not, caveat, I have not actually read through the entirety of these documents. So we're gonna do the fun thing. We're gonna live stream it. We're gonna go through, talk about what's happening, what's up, and see if we need to go further with them. From the chatter I've seen, from the snippets I've read, neither of these documents are overly surprising or novel in any sort of way, but they do merit discussion. Obviously, today, of course, was the deadline for discovery for Monica and Ron Toye. We'll talk about that as well. What else should we talk about? What else should we talk about? We've got what do we got? Oh yeah. I should probably get that letter, right? I should probably do that letter. Oh boy. What a cute super chat. I'll read it in due time, Greg. Just a minute. Hold on, let me go get that letter. Okay. Look at that. Chair stream. Chair stream. What is this? What is it? Oh no! What could it be? What could it be? I'm surely out of a job and disbarred now. Oh my goodness. Oh my goodness. All right. So we've got all sorts of stuff, but here's what you do, right? Here's what I do. You guys know this. I always lead with my mistakes. Always lead with my mistakes. Because at the end of the day, this channel is about education and entertainment. And so earlier today on Twitter, I was asked a question about Jamie Markey's Mitigation Act letter, right? See, there's actually one of the lawyers out there who's critical of what's been going on. He has been discussing things in a very civil manner, and he's actually pleasant to talk to, and he engages in what we call good faith discussions. Good faith discussions are fun because you can talk freely. Unfortunately, when you're having a good faith discussion with someone, there might be a bored other attorney out there desperately following your Twitter, just hoping against all hope that he can pull a gotcha out of that conversation, and that's fine. That's fine. So there was a question about Jamie Markey's TDMA letter, and a question about what else could be brought in there, and I have misread the TDMA in one portion, and so I posed a hypothetical that there might be other statements that are not revealed yet that would have been spoken statements. That would be a hypothetical to the situation, and I had misread the TDMA, and I'll explain why. So the Texas has a libel statute, specifically lays out the definition for libel. Texas does not have a slander statute, and slander is not incorporated into the libel statute. Libel is defined under Texas code roughly as broadcasts or written publications, not publication in the slander in the sense of communication to another person. It's weirdly limited to libel. So that doesn't mean you can't bring a slander action in Texas. It would just fall under the common law definition of slander rather than the statutory definition of slander. So the Texas Defamation Mitigation Act is nested in the libel statute. It's a subsection of it. Because of that, I missed the part where the TDMA does cover oral communications, which also I find to be a little bit illogical. In fact, I think the whole statute is stupid and archaic, and I'm not the only person who thinks that, but that's okay. It's there. So in the subsection to the statute, it does say it covers oral communications. I had missed that. So in the hypothetical that I was discussing, yes, I suggested that unwritten communications might be able to be included, which was a misunderstanding on my part. Now, one lawyer corrected me in the thread very politely and asked me to look at some things. And when he did, I went ahead and admitted my mistake because, mistakes happen. So I did that. And then T. Greg decided to go ahead and pounce on that as some sort of gotcha. So apparently, just so you guys know, Vic has now lost the case again. I can't believe it. It's happened again. Good job, Greg, winning the case. My hat's off to you, sir. But that's how it goes. In the meanwhile, in other news, it's completely irrelevant to the case at hand. It was a abstract discussion in the hypothetical. So all sorts of fun, but always lead with your mistakes. The TDMA does cover oral communications. Now, you tell me what good a retraction, correction, or clarification does for an orally defamatory statement that does damage to someone, and how you would go about retracting that. I guess they would call them and say, nah, bruh, just kidding. What is that? This is the weird part of that statute, is that the retractions are not required to be of substantially equal value to the statement themselves. There's almost no way you can submit that a retraction on a defamatory statement would actually undo the damage. It might, I guess it is called mitigation. It might mitigate further damage, might. But we've seen how news stories have done it, right? You get front page news of something, and then 2 weeks later, you get a 9th page retraction, and that is supposed to make everything better, and no one seems to like that at all. So, mea culpa, mea culpa. That said, I will still suggest that there is more than enough to carry this case past the TCPA and past summary judgment. And if the lawyers want to have their parade on Twitter, they can do that, especially if they want to do it over a gotcha of my misunderstanding of one section of the TDMA. But that's okay. That's what lawyers do, right? We argue vehemently with each other. It isn't that big of a deal. So, that said, we will be starting with this. Oh, should I start with the letter that I got? I just teased it. I suppose I should bring it up, right? Right? How do we do that? I didn't scan it in. I just got it. I've been gone all day. I wouldn't want to dox this person's PO box. That would be unfortunate. Let's see here. What do we got? What do we got? I have something nearby that I can use to censor this stupid person's PO box. Let's see. You know what? I'll just do it this way. Don't worry, I'm not going far. You guys can probably still hear me. I'll just scan it in and do it that way. Da 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 da. Give me just a second. I'll have it pulled up for you guys. All right, so we'll do the early super chats in a bit. We will. I'll discuss what's coming up for the rest of the week, and yeah, and then talking about this week and next week. And then we'll get into the meat of the documents for Richard Meyer, and then we'll go ahead and get into the documents for whatchamacallit, Vic. So that'll go for a while. Let's see. Where do I put this? Here we go. That's great. So, by the way, Greg, welcome to the show. Anytime you want to talk, Greg, you can come and pay $20 and talk, and I'll address it directly. Whatever you want to say, buddy. That's the rule. That's the rule here. So, all sorts of fun with that. Never let me discourage you from giving me money. Go. All right. Almost there. I'm so good at this. Oh my goodness. I hope you guys are having a good day. Right? I hope you are. Because having a good day is important. Okay, we'll get rid of this. And we'll get rid of this guy's name. Not really important for him to be on there. Apply those. Okay. Okay. This is a short one, y'all. This is probably overselling the fun of this letter. That's why I didn't put it in the description. We'll do that. Okay, here we go. All right, here we go. We've got it right there. Oh, it's a little big. Let me shrink it down. There we go. Okay. So, here's the letter. Here's the letter. Miss Melinda Scott. Miss Melinda Scott. From the Lawyers Professional Responsibility Board. Now, remember, this letter is to her, not to me. I am just CC'd on it. They have humbly CC'd me on this. R.E. Nicholas Robert Ricada. Dear Miss Scott, I have reviewed carefully the file in the above matter. Pursuant to the rules on lawyers' professional responsibility, I approve the disposition made by the director. The director's office has properly determined not to investigate the complaint. See comment to Rule 8.4, Minnesota Rules of Professional Conduct. Although a lawyer is personally answerable to the entire criminal law, a lawyer should be professionally answerable only for offenses that indicate a lack of those characteristics relevant to the practice of law. So, interestingly, I am also not being asked to answer for any criminal violations. There was no crime committed in making fun of this lady who has represented herself in, I think, 5 straight federal lawsuits against the same person and had all 5 of them dismissed for the exact same reasons, with pretty much copy and pasted opinions from the same judge, who is telling her over and over again in not very subtle language to get a lawyer. So when I tell her that she should get a lawyer if she wants to successfully sue Joshua Moon and the Kiwi Farms or whatever, apparently that is in her mind a violation of the professional responsibility that I have. Lady, Melinda, I'm telling you to get a lawyer, and you're trying to convince a bunch of lawyers that me saying that is against my responsibilities as a lawyer. I don't think they're gonna agree with that. Don't think so. They kind of hammer it in your head that when people ask you what they should do, you suggest they should get a lawyer, even if it's not you, especially if it's not you, right? You just go ahead and tell them, you know, that's a really complex matter, and you should hire an attorney. You could talk to me, or maybe even if you don't want to talk to me about it, I could refer you on to someone in my network who'd be happy to look into that for you and give you some recommendations. Let's do a consultation, or let me set up a consultation with someone else. That's how that works. But you know, this is what everybody seems to keep forgetting, is that when you're not representing someone, you do have the basic protections of the Constitution that everybody else does, even though you're a lawyer. Now, I know that's hard to remember because lawyers are barely people, if they are people at all. And if they are, they're the worst people on the planet. But they do still get constitutional protections of free speech and all of that stuff. So there you go. That one's been brewing a while. She went ahead and appealed that. That's been at least a month waiting for the answer to this letter with bated breath. So, all right, let's go through the early super chats, and then we'll go ahead and start into the documents, which I'll put over here. The documents for whatchamacallit, Richard Meyer versus Mark Waid. Mark Waid. Let's see. Joni Baloney says, Rise of the Shield Hero is Vic Mignogna's story, only animated. Change my mind. Got no reason to change your mind. Also, subscribe to my channel. Still convinced that Shane was a paid shill of Nick's. It can't be real. No, I would never pay Shane. Never. For anything. Gross. Think of the shoes that would be bought and consumed. Ink Penification says, let me know when you want to set up a technology stream. Also, mostly I'll get an offer for work, so I will only catch these streams on Friday if I get an offer. Cheers to a good life. By the way, you ought to cosplay as McNulty. McNulty's a great character. Very, very good. The Wire's a great show. Amenthi says, I saw a car with a bumper sticker that said, take the law in your hands, hug a judge. Do you think that's a good idea, or do you think he will hold me in contempt? I don't want to know what a contempt hug from a judge is like. But I imagine there would be a social media brigade against them post haste. T. Greg Doucette. And I hope that's really you, Greg. Surprised you even decided to stream today after how badly you got it handed to you on Twitter today. Why'd you say today twice about the TDMA? Of course you will never invite me on. I did invite you on. You never responded to me. No, I won't invite you on now, though. That's fun. You can always come pay me to talk. That's how we'll do it. It'll be great. Let's see. TB/AI says, do you think lawsuits such as Vic's, Meyer's, Covington kids will be used as case law or may rewrite laws to more effectively discourage SJWs from doing what they're doing in the future? It really depends on how they go, right? Meyer's case looks like it's going to pass at least his first jurisdictional motion in part and probably in full. We'll take a look at that and what that means. Vic's case will really depend on how it goes. Again, there's a bunch of lawyers on Twitter. There's a bunch of lawyers on Twitter who think that Vic has no case at all. Of course, they don't have all of the information that's available, and they don't know the full legal strategy, nor do I, behind Vic's case. So we'll have to see, right? Again, it's kind of weird that no one has filed that TCPA motion. I know they have 60 days to do it, but if they thought it was completely frivolous, they could, sure looks like they could reduce costs on their clients by filing it. But, you know, I'm not the defense attorney either. So we'll have to wait for the TCPA. We'll have to wait and see. I'm working on getting a nice synthesis of the current interpretation of the TCPA in Texas, because I think that some things might be missed and some rulings might be missed because of the court's muddy handling of the situation so far. And so once I can do that, I'll put it together. That might just be a 15-minute video on it rather than a full live stream. We'll see. I don't know if it merits going through the entire body of work, but you know, like I said, we'll see. I haven't done it yet. But yeah, I mean, they again, I don't know that these cases will set legal precedent. I don't know that these cases will set legal precedent. I think they'll set they set social precedent, right? The fear of every lost case, and even cases that are won but are expensive, sets a social barometer that people go, okay, wait a minute. They had to pay a lot of money to get to where they were. And they had to pay a lot of money because the case wasn't frivolous. And that's kind of scary. One of the cases I brought up earlier in the week, and I acknowledged, see, this is interesting. I acknowledged that the case was eventually lost on appeal. And I talked briefly about the way that it was lost. But people use that to now say that I lied and said that the case was won, which is not true. That is not actually what I said at all. In my first tweet about it, I suggested that they won. They did win at the jury. And then as I read further, I found out that they had lost, and I corrected it in the same line of tweets, in the same thread. It's all there. And when I do a thread of tweets, it's like 4, not 4,000. So it was not that hard to find that I had said, actually, they ended up losing, but they lost on procedural grounds rather than on, rather than at jury. And that's something important to remember, because you might win on appeal. You might overturn something on appeal. You might not. You also might not. And it was an interesting case because it was in Tarrant County, and a Tarrant County jury found sufficient cause to award $13 million to a couple over defamatory statements, per se defamation. What's interesting is that the educational value of that is more on what is a Tarrant County jury going to be looking at What have they done in the past? Here you go. Here you go. This case, surviving TCPA, surviving summary judgment, will have to go before a jury and have those questions answered. And what the jury does, we saw what happened in the Oberlin College case, right? A jury awarded a massive award because seems like they think the college are a bunch of pricks. Well, if you've got defendants who are pricks, they might not like that too much. They might not like that too much. So we'll see. We'll see what happens. But again, this is why discussion on Twitter, which happens in clips, is not the most productive way to discuss these matters. But alas, it's what we have. Alas, it's what we have. But yeah, I do think those big jury verdicts that get national news and stuff like that really do stand to discourage people from these mob tactics. But again, briefly on the mob tactics, if you think, now let me preface this, I'm not a victim. This is not a call for victimhood or anything like that. Absolutely not. But I do want to point out something. If you think what's going on right now on Twitter is not part of a coordinated push, then you have to just read the words they're saying, where they're saying this is a coordinated effort to go after me. They really, really don't like having me out here talking about this. And again, I'm not inferring that. It's not conspiratorial. It's explicitly stated by this group of very, very bored people who are not involved. They really hate the fact that I've been discussing this for months. They don't like it at all. So now they're doing the first step of what they do. The first step is they're attacking my reputation. So they found a couple lawyers to come after some things and take particular things and go after them. Mine and Ty's, of course. Of course. We wouldn't want lawyers representing people, right? Because what you should do is, when a lawyer represents someone, like coming after me, I get it. I'm acting as a media personality. I'm out publicly talking about this stuff. Yeah, going after Ty's reputation's a little bit different and a little more nefarious, isn't it? Right? Because if you go after Ty's firm just because you don't like his client, then you're kind of being a chump, especially if you're a lawyer, because you know that you've represented some scumbags in your time too. So no matter what your opinion of their clients are, trying to go after the lawyer because you don't like their client as a lawyer is pretty gross. So yeah, that's fun. That's fun. But so the next step, obviously, the obvious next step is they'll be coming after the monetization on my channel. It's step 2, right? Break the reputation, break the income, and then pray to God that the person can't survive that and doesn't talk anymore. That's the goal. That's the goal. It's coming. I know they're going to be doing a coordinated push on YouTube. They're going to use a picture that is so old and out of context that that not even the elder statesman attorneys who were commenting on this were out of law school at the time. They'll take that stuff right out of context and suggest somehow that I'm unfit to be a lawyer, unfit to be on YouTube because of a picture from 15 years ago, whenever that was. And they try it every time, every case I start covering. So, yeah. So that's the next step. I'm expecting it. We'll see. Can't stop it. You can't stop these people from doing it. It's sad, though. It's sad that someone who calls themselves a Republican is just lining in with the social justice people. Hey, newsflash. None of them like your politics, buddy. Watch your back. Watch your back. They don't. They don't. Just because you're not for Trump doesn't mean that you're on their side. And these are people who destroy. So my hope to you is that they never turn, because that would be unfortunate. So, you know, there you go. Oh, they also hate you because you're a man. I mean, presumably a man. But yeah. Oh, guys, I thought of something today. So on occasion, I will offhandedly brand someone with a little moniker. I'll brand someone with a little moniker, okay? Like Cuck Lightyear. And now you can't put Cuck Lightyear on a shirt because not everyone wants to walk around wearing a shirt that says Cuck. I mean, it's funny to sell a shirt that says Cuck Lightyear, but no one will buy it, right? I get that. Now, since it's Teespring, you don't have to have any inventory, and that's fine. But would you guys like a Cuck Lightyear mug or stickers? Because, I mean, these things, I can make it. I was thinking of doing, like, you know, the Buzz Lightyear look with, like, a CPAP machine on the outside of the helmet. I thought that would be a funny mug or a funny sticker. And we've got, you know, I do want to do Cuck Dynasty characters shirts for the various actors. That might be fun, right? So, but I understand not everybody wants to walk around with a shirt like that on, because people in public don't get the joke. But stickers and mugs, I think that's where that is. So we'll do those. I might not do like stylized art. We might just Photoshop them, because I think that might be really funny. But we'll see. We'll see. Soy Story. I'll do Soy Story mug. Oh, thank you, whoever said that. I missed it. Okay, I'll work on those. You know, during this upcoming week with Matsuri, I'm going to be gone, and I think my streaming time is going to be pretty limited, and so my art guy probably won't have to work on thumbnails as much. Maybe we can put some stuff together, or I can solicit out for some fan photoshops of these things and pick them. But I was just thinking about that earlier, because you know, mugs and stickers, man, you can. And the stickers are like $3-4. So let's see. McGurd, I'm in the big time, says T Greg chat 2, please donate $20 to my CPAP GoFundMe to cover the cost of sanitary wipes I just spent on super chat. Thank you. Andy M says, so will Greg hold up better than Shane? Maybe, but not by much, lol. Top Secrets, thanks for the donation. Ryan Mercado says, dang, Greg's really thirsty for your attention, going so far as buying a super chat just for that. Is he really that desperate for attention? In fairness, I think that is a troll account, but we may never know. Skeet Neat says, donated $100 to the Vic's fun thing that I can't type out for some reason. Hope that helps. Donate 20 of sweat money for Meyer and all that he is doing to help comics. Tom King is an untalented hack fraud of a writer. Hey, thank you. The reason you can't do it is because the porn bots came in, and I mean, it was constant link spam in the chat, and I had to disable links for anybody but me and moderators. I'm really sorry. I don't like doing that. I really don't. But there's no other tool to actually get rid of them. And they were spamming so much that the chat was lagging. I couldn't even hide the porn links fast enough to stop them. So that's why that was going on. So sorry you can't post the link. But that being said, let's look at the GoFundMe real quick. Wow, awesome. The GoFundMe is at $177,445. That's so fantastic, guys. Thank you for continuing to support Vic. Even though I keep losing the case for him, I really do appreciate it. And again, for legal purposes, I do not get a dollar, a dime, a penny, a crumb from the GoFundMe. It is all going straight into the IOLTA account of Beard, Harris, Bullock, and Hughes. Any excess funds will go to the Dallas County Salvation Army Battered Women's Shelter, as stated in the GoFundMe. So there you go. Next, but again, Skeetney, thank you so much for the donation. That is awesome. Mr. Obi-Wan 2020. So did you hear that Oberlin University decided to send out a mass email criticizing the jurors in the defamation case before the final damages have even been declared? Big oof. Yes. Ty and I actually briefly discussed this yesterday. I think we are going to work on doing that Oberlin series to kind of walk through a day by day of the trial and talk about that, because that's something you don't really get too much of. And I think having Ty's expertise on that will be very helpful. Yes, but we did talk about that. Stupid email to send out. If you aren't going to say something nice about the jurors prior to your exemplary or punitive damage motion hearing, say nothing. But what they should have done was put out a letter apologizing, in the hopes that the jury will see that they've learned their lesson. But, you know, good job them. Frostbeard2 says, after your recent streams comments, I decided to look up EFAP and this Legal Eagle Marvel thing. Wow, don't watch. That individual is the reason lawyers are known as sleazy scumbags. It was shameful. Have a good stream. Yeah, I have trouble consuming Legal Eagles content, so I don't know if I'll do any sort of thing today. Or not today. I definitely won't do something today, but on it. Timothy McDaniel. Yes, I did get your email, buddy. I will respond to you in due time. Dustin Masberg says, hi, and Nick, it's my 21st birthday. What would you recommend as a drink? Can I get a how embarrassing? Yes, you may. And happy birthday. What would I recommend as a drink? It depends what you're trying to do. But no, if you're at a bar or whatever, just get a Johnny Walker Black. Get a double. Take it slow and enjoy it. Do that. T. Greg Doucette says, okay, fine. You know what, Mr. Poo-Poo Head? I don't want to come on now. I have a perfectly fine goat to inseminate. Good day, sir. RRU ooh-woo. Thanks, Greg. Glad you're learning that internet speak. The Shady Man says, Nick and Ty should be DLC or extra characters in the next Ace Attorney game. What would their war cries be? Mine would be how embarrassing, and Ty's would probably just be a fist. Ink Penification says, here's what confuses me. It doesn't matter if you're pro or anti-Vic. I never understood why the defendants were not let go for unprofessional behavior. Actors should only use their Twitter to promote their films, and that's that. Yeah, that's definitely a thought on that. I'm not really a fan of companies censoring their actors' words on Twitter. But I mean, when these people start insulting their own fans, that's weird to me. When you're insulting the anime community, or a good percentage of the anime community, and you're alienating fans, that seems like that's behavior I wouldn't tolerate as an employer. But you know, there you go. Olron1 says, so did Shannon McCormick really bring in Duchette for this? Wow, I have lost even more respect for him. What a scumbag. According to his tweets, apparently he did, but I don't know. Yeah, I think he had a tweet where he said that's why I tagged you or whatever. Okay, let's go through the Meyer documents, shall we? Let me, why is that doing that? Whoops. I'm trying to get the right zoom on here. Oh my goodness. That's a little better. Okay. All right, so this is where we left off in the Meyer versus Waid saga. If you do not remember, here's a brief summary. Richard Meyer sued Mark Waid for tortious interference and defamation He sued him in the Western District of Texas, which is federal court. Mark Waid is a resident of California. Richard Meyer is a resident of Texas. Meyer sued Waid for tortious interference on the claim that Waid contacted a small publisher, Anarctic Press, and levied some undue pressure upon them, and they decided to cancel their contract with Richard Meyer. Okay, so that is the tortious interference claim. The defamation claim involved on the pleading. The defamation claim involved whatchamacallit, defamatory statements about Meyer being a white nationalist, a Nazi, and about him publishing the names and phone numbers of employees of comic book shops. He alleged these to be false statements. However, he only in his pleading, I believe, mentioned the online publication of these statements. So the online publication of the statements by Mark Waid were tested for jurisdiction in Texas, and there were subsequent statements made by Mark Waid in Texas that were substantially similar to the online publication statements, but those were not in the initial pleading. They were brought up on the jurisdictional motion, but that's where we are now. So both sides submitted motions, Waid's side submit a motion to dismiss based on lack of personal jurisdiction over Mark Waid. Meyer's side countered that, opposing the motions, and in federal court, the court has, we'll call it personal jurisdiction over each independent claim, right? So the tortious interference claim is separate from the defamation claim. The spoiler warning and short story of this is that the magistrate has recommended that the defamation case be dismissed on jurisdictional grounds, while the tortious interference case proceed on under jurisdictional grounds. So each count is actually weighed independently as to whether or not the court has jurisdiction, and it's because those are fact specific to the actual causes of action that are there. So this will become a little more clear, but as a refresher, that's where we're at. And I did realize I have a couple Streamlabs to read real quick. Daki Makura says, latent gay. We need to epitomize your latent gayness in crowdfunding a Daki. You on one side and ... Okay. Gay and Still Large says, would the title song of Soy Story be I've Got a Friend in Her? Come on. Think we could get Randy Newman? I got a friend in her. Oh, that would be great. That would be great. Oh, I haven't talked about, sorry, my brain is all over the place. I think it's a little bit fried, but I haven't talked about one other way that I've been under attack lately. And I'm not sure where this is coming from. Like, I cannot particularly attribute this to Kick Vic, okay? But I do think I have an idea of who is doing it. I got an email from a BuzzFeed attorney, okay? Because a BuzzFeed writer allegedly received a communication from my office, okay? So it was a communication from Retraction Law, purportedly. Now, it wasn't on my letterhead, and it just used my law logo and purported to be me. It wasn't from my law firm's email address. So, but this letter went to a BuzzFeed freelance writer and demanded that they take down some publication that they had made and offered to pay them $8,000 to take down the publication. I, being unaware of this, I received a phone call the other day from this BuzzFeed writer. And they said, hey, I could barely hear him. The phone was breaking up. I was in a part of my house where the cell service is not great. They're talking about, I just wanted to talk to you about that offer that you made, blah, blah, blah. And I was like, what are you talking about? Please email me. So they emailed me and said that they would send me their banking information, which was a little bit forward. So I could wire the money to them. And I said, whoa, hold on. Please don't send me your bank information. I didn't send you anything. So I got an email from the BuzzFeed staff attorney suggesting that Mr. Joshua Moon was impersonating me. So what I am to believe, apparently, is that Josh Moon of Kiwi Farms is impersonating me by doing a bad fake of my letterhead, which doesn't look anything like my letterhead, and sending letters to BuzzFeed writers on behalf of Kiwi Farms. We all know that that's how the farms operate, is they send fake legal threats. That's what they do. I have a feeling I know exactly what was going on there. I know with relative certainty that Joshua Moon had nothing to do with that. So I have a feeling someone was trying to get BuzzFeed maybe interested in my channel or law firm or whatever. But yeah, I don't know who did it. Maybe it was the BuzzFeed writer themselves. I have no idea. Maybe they're trying, because that would be the ultimate in fig ops, right? The BuzzFeed writer tries to convince me to be mad at Josh Moon. That almost seems like a plausible fig op. Well, I don't believe that Josh did that. So there you go. Is that fraud? Oh, yeah, that would be, whoever did that, that was absurdly illegal. It would probably be a federal felony, mail or wire fraud. Even if it was the BuzzFeed person who did it, even if it was Null who did it, whoever it was who did it, that's absurdly illegal. Yeah. So there you go. But no, if anybody gets a weird fake letter from me, I probably didn't send it. But you can always, verify with me if I did. But yeah, so again, just so you know, that's part of what's going on as well. And if, again, some people may call it conspiratorial or not. I don't think so. There is a group of people admittedly colluding openly on Twitter to do various things to me and to cause quote unquote legal trouble. So hopefully none of them get caught. That would be bad. Blaine20 says InfoWars settled. Paid $15,000 to Matt Fury. Case precedents dodged. Probably. Getting out for $15K? That's cheap. I'm guessing Alex made more than that on the posters. Matt Fury might not have ever made $15,000 in his life, so that's good for him too. Lots of these things settle, and probably should. There's no precedence that was at risk until they appealed it. But yeah, I mean, so yes, case precedence is dodged, but that's very interesting that they settled. And I'll tell you why, right? Because neither of them won on summary judgment, and these preliminary motions need to happen to push those settlement talks along. Sometimes they were caught in a back and forth over the ownership of Pepe and all of that stuff. They were really dragging it out. I'm sure Matt Fury was feeling the sting of the legal fees, right? And I'm sure Alex Jones and InfoWars wanted to just get this off of their plate. And when neither of them won outright on summary judgment and it looked like a jury trial, you're talking, again, at that point, another, who knows, tens of thousands of dollars in addition to what they had already each forked out to go to jury trial over probably a minimal amount of, minimal in terms of Alex Jones money, amount of sales on posters. Like, so 15 grand to Matt Fury. They probably agree to no longer sell the posters, which they don't need to sell anymore. And it's all done. So there you go. Moist John says, BuzzFeed's Beautiful Joe Bernstein back at it, trying to kill off right-wing comedians and e-celebs. Sam Hyde and Soph was not enough for him. I don't know who it was. The person, whoever it was, the writer from BuzzFeed does have a Kiwi Farms thread about them. So good job. Good job. Okay. Let's, back to the document. So before the courts, our defendant's motion to dismiss for lack of personal jurisdiction and related briefing, after which the motion to dismiss was referred to the undersigned for a report, the undersigned being the magistrate judge, for report and recommendation as to the merits pursuant to 28 U.S.C. 636B, Rule 72 of the Federal Rules of Civil Procedure, and Rule 1 of the Appendix C of the Local Rules of the United States District Court for the Western District of Texas. After reviewing the pleadings, the supporting evidence attached to the pleadings, the relevant case law, and the entire case file, the undersigned issues the following report and recommendation for the District Court. Background. Plaintiff Richard Meyer brings suit against defendant Mark Waid for tortious interference with contract and defamation, seeking actual, special, and exemplary damages in excess of $75,000. Docket number 1. Meyer is a citizen of Texas and Waid is a citizen of California. Thus, this court has subject matter jurisdiction over these claims pursuant to 28 U.S.C. 1132. According to the complaint, Meyer is a comic book enthusiast who created a YouTube channel to review comic books in April 2017. Channel is called Diversity in Comics, and its intention is to provide comparisons of the superhero comics produced by Marvel and DC Comics in the 80s and 90s to the comic books that were being produced today. He described newer comic books as politicized and observed that his aggressive criticism of newer books was specific and often biting, sarcastic, and hyperbolic, noting that at times his attempts at sardonic humor fell flat. His views gathered a very vocal group of detractors, including Waid. Man, it's amazing how public views on YouTube do that, right? who has his own substantial online following. Meyer alleges that Waid has described Meyer as a serial harasser of women and minorities and claimed that Meyer promotes hate and intolerance. He further alleges that these statements were intended to discredit Meyer and detract from his vocal calls for fundamental change within the comic book industry. In April 2018, responding to criticisms that, quote, he had only complaints about the emerging low-quality product and no solutions or appreciation for the difficulty of creating quality work, Meyer announced that he was publishing his own comic book, Jawbreakers: Lost Souls. Meyer began talks with San Antonio-based publisher Antarctic Press to publish and distribute the book. By May 9, 2018, following a crowdfunding campaign to finance the book, Meyer alleges that he and Antarctic Press had agreed on the terms for publishing Jawbreakers and that AP had, quote, agreed conceptually to publish future comic books written by Meyer. Meyer alleges that the very same day, rumors and leak chat transcripts suggest that certain retailers aligned with Waid and his followers had agreed not to carry Meyer's book and to boycott Antarctic Press because of the misinformation being spread about Meyer and his views. But according to Meyer, Antarctic Press was unfazed. Later that evening, it announced the coming publication on its Twitter account. Blaine Storm says, thanks so much. My sister takes the bar this summer, and you have given me enough knowledge to surprise and tease her as an older brother should. I guess I should also shout out my Japan travel channel, Blaine and Katie. Cheers. So you guys can check out Blaine and Katie if you want to learn about Japan travel, I suppose. Happy to assist and have fun razzing your sister as she becomes a terrible person. Following this announcement, Meyer alleges that Waid tweeted about Antarctic Press's interest and called an owner of Antarctic Press. He alleges that Waid convinced the owner that, quote, Antarctic Press should repudiate its contract with Meyer. Antarctic Press, quote, caved to Waid's pressure and issued a statement that it would not release Jawbreakers. Then, quote, Waid deactivated all of his theretofore quite active social network accounts without explanation. Meyer alleges that he was, quote, blackballed by Waid, and as a result, his, quote, only option was to self-publish at significant expense and with significant delay. The complaint also alleges that Waid has described the events of May 11th in interviews and on comic convention panels, suggesting that Meyer was encouraging his followers to harass or threaten comic book stores' employees. This motion to dismiss was filed on November 2nd, 2018. Following several extension requests, Meyer filed an unopposed motion to conduct jurisdictional discovery. That relief was granted on November 29th, 2018. Following that jurisdictional discovery, briefing on this issue continued, with Meyer's response filed on April 12th, 2019, Waid's reply filed on April 22nd, 2019. The briefing by both sides contained significant argument as to the merits of plaintiffs' claims. However, the undersigned's analysis focused on the jurisdictional allegations and evidence in considering the motion to dismiss for lack of personal jurisdiction. Personal jurisdiction. Applicable law. When the court rules on personal jurisdiction without conducting an evidentiary hearing, the plaintiff bears the burden of establishing only a prima facie case of personal jurisdiction. The district court is not obligated to consult only the assertions in the plaintiff's complaint in determining whether a prima facie case for jurisdiction has been made. Rather, the district court may consider the contents of the record at the time of the motion. The court shall accept as true the non-conclusory, uncontroverted allegations of the party seeking to assert jurisdiction and resolve all factual conflicts in favor of the party seeking to invoke the court's jurisdiction. This is interesting because this is actually very similar to how the Texas Supreme Court has decided to invoke the TCPA. Okay? It really is. And this is going to be indicative of how Waid's counsel will proceed, because the logical step following the motion to dismiss on jurisdictional grounds would be to try a TCPA. Now, they're well after their 60-day limit. I don't know if they have any agreements to postpone the filing of the TCPA. I feel like they might. I feel like they might have something like 10 days following the order on jurisdiction to file the TCPA. I think I remember reading that. I'll have to check up on that later. But the logical next step is the TCPA. However, if the Texas Supreme Court in a case, I haven't fully briefed the case, but I believe there's a case out there, a very recent case, like as recent as last winter, where the Texas Supreme Court has laid out that prima facie means prima facie case, and the clear and convincing evidence standard that's in the TCPA statute is not actually the standard. So what they'll do is they'll take the factual allegations, they will not allow them to be controverted by a set of facts from the other party, and those factual allegations, if true, making a prima facie case, will allow it to defeat the TCPA. But again, this is how they're defeating the jurisdictional argument, and I'm just suggesting that it's probably pretty close to how the TCPA is interpreted, but I do have to clarify that. So, although jurisdictional allegations must be accepted as true, such acceptance does not automatically mean that a prima facie case for personal jurisdiction has been presented. So again, it's non-conclusory claims. You can't just say we have a prima facie case because we do, right? Like, you have to present facts that lead to the prima facie case, and that means they have to satisfy all of the individual elements of the question for the court. So specific jurisdiction is a claim-specific inquiry. It focuses on the relationship among the defendant, the forum, and the litigation. Texas's long-arm statute extends to the limits of federal due process, which permits the exercise of personal jurisdiction over a non-resident defendant where, 1, the defendant has minimum contacts with the forum state, i.e., whether it purposely directed its activities toward the forum state or purposefully availed itself of the privileges of conducting activities there. 2, the plaintiff's cause of action arises out of or results from the defendant's forum-related contacts. And 3, the exercise of personal jurisdiction is fair and reasonable. Touchstone of the court's inquiry is, quote, whether the defendant's conduct shows that it reasonably anticipates being hailed into a Texas court. A forum state's exercise of jurisdiction over an out-of-state intentional tortfeasor must be based on intentional conduct by the defendant that creates the necessary contacts within the forum. The defendant bears the burden to show that that exercise of specific jurisdiction would not be fair and reasonable once minimum contacts have been shown by the plaintiff, and such a finding is rare. The court examines 5 factors in this inquiry. 1, the burden on the non-resident defendant. 2, the forum state's interests. 3, the plaintiff's interests in securing relief. 4, the interests of the interstate judicial system in the efficient administration of justice. And 5, shared interests of the several states in furthering fundamental social policies. So I hope you guys are following what's going on here. I hope you guys are following what's going on here. Yes, so they're gonna be answering first these 3 questions, and then they'd be answering the 5 questions that follow if they pass those first 3. Hey, Misty. Happy birthday, and thank you so much for that. I really do appreciate it. That's great. Analysis. With the benefit of jurisdictional discovery, Meyer alleges and provides evidence of 2 straightforward contacts by Waid with Texas. Waid initiating a phone call to San Antonio to one of the parties of the contract, soliciting a return phone call, and then encouraging that party to breach the contract. And 2 weeks later, Waid traveled to Texas and publicly defamed Meyer, a Texas resident, at a Houston comic book convention. First, a tortious interference claim. Tortious interference with an existing contract claim exists when a defendant causes a third party to breach their contract with the plaintiff. Here, Meyer alleges that Waid tortiously caused a Texas company to breach its contract with a Texan. Now, remember, well, never mind. To support this theory, he alleges, and the parties appear to agree, that Waid called a Texas company on a San Antonio landline and spoke with an office manager for the company. When the owner returned his phone call later that afternoon, they spoke at length, discussing Meyer's book for 27 minutes. Waid responds that he was previously unaware that Meyer was a resident of Texas, did not know at the time he made the phone call to Antarctic Press that Antarctic Press was a Texas company. This fact is disputed at this stage. The court must resolve factual conflicts in favor of the party seeking to invoke the court's jurisdiction. So that's Meyer, right? Meyer says, here's how these go. When you have these disputed facts in these motion hearings, Meyer says, I want jurisdiction. Waid called a Texas company. Waid says, I didn't know it was a Texas company. Well, Meyer's fact wins because Meyer's trying to get jurisdiction. So that's just how it goes. Did not know that the landline number he called was a San Antonio, Texas number. He argues that his, quote, ignorance that plaintiff was in Texas defeats any finding of jurisdiction as a matter of law. None of the cases cited by Waid for that proposition is completely analogous to these facts. 2 of the cases, Ravel and Fielding, focus on defamation claims rather than tortious interference claims. See Revel versus Lidov, finding no personal jurisdiction over defamatory statements concerning Texas resident posted on the internet where the article did not mention Texas and was not specifically directed to Texas readers. Fielding versus Hulbert Berta Media Inc. says, finding no personal jurisdiction over defamatory statements published by German news magazine with very limited Texas circulation when plaintiff did not demonstrate a Texas residence during any relevant time period or any more direct aim of the harm towards Texas. And then Fielding also included a claim of tortious interference with prospective business relations, but it was not individually addressed by the Fifth Circuit. The remaining case Waid highlights, Fester, is closer to the facts at hand, but also distinguishable. Fester v. Wolf. In Fester, the jurisdictional dispute was as follows. Defendant argues that she lacks minimum contacts because she did not solicit the buyers in Texas, communicated directly with the representatives of Misión La Serna in Mexico in connection with the sale, had no direct communication with the plaintiffs, and did not know plaintiffs were Texas residents when signing the interim agreement or the letter of intent. Plaintiff argues that Wolf made misrepresentations in phone calls with Texas residents, made misrepresentations in a contract she sent to Texas residents. Plaintiff's claims arise out of these contacts with Texas. Plaintiff lost nearly $750,000 in Texas, and Wolf made no effort to guard against suit in Texas. The Fester court concluded that, quote, though the allegedly tortious statements contained in the relevant contractual documents eventually made their way to plaintiff in Texas, it cannot be said the defendant purposefully directed the tortious statements to Texas. It focused on the facts that the dispute surrounded a property in Mexico. Communications that gave rise to the claims most directly were sent directly to Mexico, not to Texas, and the fact that there was a dispute as to whether the defendant knew the plaintiffs were in Texas at the time of the fraud. Here, although defendant also disputes knowing plaintiff was in Texas at the time of the allegedly tortious conduct, the facts are otherwise different. Waid's phone call underlying the tortious interference claim was made to a Texas company at a Texas landline phone number about a Texan. Waid's best cases, distinguished above, all precede the Fifth Circuit's recent guidance in Twa versus Apple Tree Auction Center on precisely this point, which reiterated that a single communication may be enough to establish personal jurisdiction in an intentional tort claim when a non-resident defendant places a phone call to the forum state and makes false statements over the phone to a forum resident. That's Twa versus Apple Tree Auction Center. Waid has not adequately articulated why this case falls outside the direction of Twa. See also Wien Air Alaska Inc. versus Brandt. When the actual content of communications with a forum gives rise to intentional tort causes of action, this alone constitutes purposeful availment. It is of no use to say that the plaintiff fortuitously resided in Texas. Accordingly, the undersigned finds that Meyer has established a prima facie case of minimum contacts over Waid with respect to this claim. So this is what we were saying. Waid called Texas. He can say he didn't know it was Texas, but he did ultimately call Texas. So that's a real problem for you. That's a real problem if you say, well, I just didn't know I was calling the forum state, but you did call the forum state, and you're talking about a contract in the forum state with two forum state residents. You're going to have a real hard time saying you didn't intend to do anything in Texas when everything you did was in Texas. Now, if he had called Antarctic Press and the Antarctic Press guy was in Florida and he called a Florida number, like he had a Florida cell phone number and he called him in Florida, or if they were normally in Florida but he happened to be in Texas when taking the phone call, but it was normally a Florida company, those would be different questions, right? If there were anyway he were calling a number that was a Texas landline is about as in Texas as you can get. I don't know how else to say it. So we knew that this was probably going to be resolved in Meyer's favor. It just doesn't make sense otherwise. DNA Crow says, haven't sent a super chat in a bit. Would ask you for another shameless plug for our YouTube channel. Instead, let me ask for a handshake and for Broly Power Maximum and myself to treat you to a drink at Anime Matsuri this weekend. Hype, my dude. Yeah, buddy. That sounds great. I can't wait for that. Okay. Further, Waid has not shown that the assertion of jurisdiction over him would be unfair. So first we addressed the first questions, right? Did they purposefully avail themselves of Texas to the services of Texas to the point where they could reasonably expect to be hailed into court in Texas? Court answers yes on that. So the next question is it unfair to the defendant to be brought into a Texas court? So Waid has not shown that the assertion of jurisdiction over him would be unfair. A defendant bears the burden to show that exercise of specific jurisdiction would not be fair and reasonable once minimum contacts have been shown, and such a finding is rare. Again, the court examines 5 factors for this inquiry: the burden of the non-resident defendant, the forum state's interest, plaintiff's interest in seeking relief, the interest of the interstate judicial system in the efficient administration of justice, and 5, the shared interest of the several states in furthering fundamental social policies. While it would burden Waid, a California resident, to litigate this matter in Texas, this factor cannot be dispositive. Here, Meyer alleges that Waid tortuously interfered. So the magistrate is a little typo there. Autocorrect sucks. Tortuously, because, interfered in a contract between a Texas resident and a Texas company. Because of that, Texas has a great interest in this case. Absolutely. Of course, Texas wants to hear this. Waid has pointed to no other considerations that render personal jurisdiction unfair or unreasonable. For the foregoing reasons, the motion should be denied as to Meyer's intentional interference claim. Defamation. All right. So here we go. There are discrepancies in Meyer's characterization of his defamation claim against Waid, but the response does not include a request to amend the complaint. In the complaint, the allegations are as follows. Through his various social media accounts, Waid intentionally published statements of fact to his followers and the general public regarding Meyer, including falsely stating that Meyer published the first and last names of comic book store employees to encourage his followers to harass and threaten them, as well as characterizing Meyer as a racist, serial harasser of minorities, and as affiliated with white supremacists. In his response to the motion, Meyer states the claim differently. Waid traveled to Texas and publicly defamed Meyer, a Texas resident, at a Houston comic book convention. Meyer goes on to argue that Waid repeated the defamatory statement to a Texas audience in Houston. Waid should have every expectation of being hailed into Texas court as a result. But as alleged in the complaint, Waid's Houston statements are not the basis of Meyer's alleged defamation claim. Meyer's not cited any authority that supports his argument that a defendant's later repetition of a defamatory statement to an in-person forum state audience gives rise to personal jurisdiction when the underlying claim only alleges, notice the italics here, only alleges earlier defamatory social media statements. Meyer seems to agree with Waid that personal jurisdiction cannot be based solely on statements being accessible on social media or the internet in the forum state. For these reasons, Meyer has not met his burden of establishing personal jurisdiction over Waid on his defamation claim as it is currently alleged, because he has not shown that his defamation claim arises out of or results from this contact. See Clemens versus McNamee, citing Calder versus Jones, finding the district court did not err in dismissing for lack of personal jurisdiction where the allegedly defamatory statements were not made in Texas or directed to residents of Texas. Recommendations. For the reasons given above, the undersigned recommends that defendant's motion to dismiss be granted in part and denied in part. Specifically, the motion should be granted as to plaintiff's defamation claim, meaning that it's dismissed, and denied as to plaintiff's tortious interference claim, meaning that it goes on. The referral of this matter to the magistrate judge should now be canceled. Objections. The party may file objections to this report and recommendation. A party filing objections must specifically identify those findings or recommendations to which objections are being made. District court need not consider frivolous, conclusive, or general objections. A party's failure to file written objections to the proposed findings and recommendations contained in this report within 14 days after the party is served with a copy of the report shall bar that party from de novo review by the district court of the proposed findings and recommendations in the report, and, except upon grounds of plain error, shall bar the party from appellate review of unobjected to proposed factual findings and legal conclusions accepted by the district court. So basically, they have 4 days to go ahead and object to this. Or 14 days, sorry, to go ahead and object to this. I am not positive here, but I believe that they could ask for leave of the court to amend the pleadings to allow to send an amended complaint to allow for them to change the basis of the defamatory claims to statements that were made in Texas. But I don't know. And the court may not accept that argument. The court may not accept that argument. My personal opinion on this has largely not changed. I think, and I think I've maintained from the start, that the tortious interference claim was the biggest claim. In my first interview with Richard Meyer, I suggested tortious interference was probably the biggest claim, or not my interview with him, but the follow-up video that I did. And then I believe I suggested that he might have a defamation claim because they were very specific about the statements about him publishing the phone numbers and names of comic book store employees. And then finally, I mentioned a very, very tenuous sort of collusion claim, not against Waid, but against these stores that had a Facebook group that was specifically saying they would drag the Antarctic Press if they decided to print Meyer's book. So I didn't think that was a useful claim to pursue. Tortious interference, I do think, is the strongest claim. The defamation claim, I find to be troublesome. I do think that the statements are defamatory. The hard part is convincing me or anyone else that calling someone a Nazi or a white nationalist is more than an insult, and it's a statement of fact. It's a hard fact to prove, because most people don't mean like a member of the Nazi party or a member of a white nationalist group specifically. Although I believe Waid said that Meyer associates with white nationalists, and the meaning of or is affiliated with white nationalist groups, and the meaning of affiliated with tends to mean member or other type of representative. So it's possible, but I think that's the thinner case. I personally think the TI is the biggest claim. I'm sure Meyer wants, obviously, both of them to go in. So I would suspect that in the next 14 days, we're going to see some objections to this. We're going to probably see a request to the court for leave to amend their complaint, to go ahead and handle those, handle the fact that it predicates it on the online statements. What's interesting is Texas has something called a rule of first publication with defamatory statements. So the first time you make a defamatory statement is when the statute of limitations starts to go. And then subsequent statements that are, I guess, substantially similar to that initial statement and can be seen as a republication of the same statement, those are not new, right? It goes by the rule of single or first publication. So there may be statute of limitations issues on this. This is a pretty technical question, and I don't do a ton of federal practice. I don't do any federal practice. Who am I kidding here? I do local practice, and so I couldn't tell you how that will turn out. I will try and find an answer to that, but we might just see. I'll try and find an answer to that by the time we see the documents, because there's almost no way Meyer's attorneys are just gonna do nothing and let this order go through. They've won on half of it. It makes sense for the economy of justice for Texas to look at both issues at the same time. So they may. What's interesting is I wonder if they would accept. I wonder if they would try and hear the case in Texas, since they're already hearing a case, but apply California law. That might be another option that they would go for. It'll be interesting. That was an argument that was happening in Stormy Daniels's case against President Trump. They removed it all over the place, and eventually it was a California district court applying Texas law to the facts. So that could be something we see here. Maybe, again, this is pretty in-depth federal civil procedure, and as a non-expert, I don't want to definitely comment on what'll happen. I will try and find an answer to these questions by the time we get the next documents, which will be in the next 2 weeks. We'll see what happens. I would expect that Waid's team will also file an objection, because if nothing else, they'll want to preserve the possibility of appealing the recommendations of the magistrate. So they'll file an objection on that first thing. Again, I don't know what they would object to. It seems pretty clear that TI did occur in Texas, if the facts Meyer has presented are taken as true. So I think Meyer is sitting very nicely on having his TI case move on. We'll see if there's a TCPA motion that follows. I would expect that is the likely next step. I do seem to recall there's some sort of either agreement or court order stating that the TCPA is extended until the jurisdictional question is answered. So we'll see that, and then we'll have another lag period of 60 or 90 days in this case, unless the court dockets the hearing sooner. We'll see. But there we go. That is Meyer's case in a nutshell. That's the status of it. Like I said, I think his CI claim is solid. It seems pretty clear that Mark Waid had no business talking to Antarctic Press about that contract at all. Even talking to them, he had no business doing so. He inserted himself between two contract holders, and he did it in Texas. That's going to be a big problem for him that he's got to overcome. that said, we can move on. We can move on to Monica Rial and Ron Toye. No, Funimation's response. We'll move on to that in a second. Discovery from Monica and Ron Toye. I don't have any information to share with you. I could not get a confirm or deny out of Beard, Harris, Bullock, and Hughes as to whether or not Discovery came in today. So I don't have the information. Ty did mention when he was on the show yesterday that he had a very, very busy day today. So the information could have come in. He has not seen it, or the information could have not come in. And what they do with that, who knows? Who knows? There's all sorts of stuff that could happen either way. Either way. But I will tell you that as soon as I know something, you guys will know something. I have heard that I can't fully confirm it, but I have heard that Casey has indeed moved firms. It looks like there's nothing nefarious. I don't have any, again, this is why I did not want to talk about Casey being removed from the Kessler Collins website. It appears that Casey has moved firms. That doesn't necessarily mean anything for the case. As of right now, he is still the attorney of record, and him being at a different firm doesn't change that. So we'll see. We'll see what is happening there. Having Kessler Collins also involved, I'm not sure what the purpose of that would be, but you know, however many attorneys they want to pay to run the case is up to them. It may be that Casey moved and the junior associate who is on the case with him is still helping him in the case. So that may persist. It may not. And it may persist for a while and then end. It doesn't have any impact on the case either way. There's nothing like, there's typically not a conflict of interest in doing that, because the conflicts of interest, would be if the firm doesn't have a conflict, or if the firm can't sufficiently isolate the lawyer to avoid the conflict, then they would, or if the firm can sufficiently isolate the lawyer to avoid the conflict, then it won't matter, right? So if they have two firms on it, great. If they have one firm on it, great. So far, Casey is still the attorney of record. But it does look like he has changed firms. So there is that. Make of that what you will. But again, this is why I try not to ever speculate on these types of, these types of developments, we'll say. Because we don't know what they mean. And they may mean nothing. Joseph Kerwin says, I finally saw EFAP 38. Legal Eagle argued that touching someone's roadmap could be considered battery. That seems flimsy. Man, that's thin. That's thin. And the question is whether or not the response is what is reasonable. Is a reasonable response to the application of force. Touching a roadmap, a paper roadmap that is held by someone, and then following that up with breaking their wrist. I don't know if that is a proportional response to a tort of misdemeanor battery. If it even is, that might be a state-specific question too, to how they define misdemeanor battery. Would something in one's hands constitute the person under the statute? Would be a question. So I don't know. Maybe I'll look into it, but we'll see. I mean, I think almost all of us can agree that that's an unreasonable response. Like if someone comes up and pulls them, like let's say you're reading a magazine, someone comes up and like pulls the magazine down, is like, hey, and you break their wrist. That seems a bit much, but maybe. Usually justifiable use of force requires some level of proportionality in the response. And that would be a felony battery without the predicate misdemeanor battery. So I don't know. Yeah, we'll ignore the stealing of the jacket and the motorcycle. We can ignore that. That's fine. All right, let's move on to Funimation's answer. This shouldn't take too terribly long, and then we'll probably wrap up the stream a little bit early tonight. Again, things have been going so hectically morning to night for me that if these streams are a little shorter, I apologize. But you know, going into Matsuri, it's kind of crazy. Okay, where are we? Hold on. I don't have that one pulled up just yet, but I will in a moment. Funimation's original answer. Here we go. Do you need to fill in this form? No, I do not. Okay. So let me read a couple justice chats. There's only 3 of those to go through, and then we'll go ahead and get into the documents, and then we'll address the rest of the super chats at the end. Of course, you know, the bigger super chats that come in, I'll address right away. These Hand says, steady there, Nick. Lawyers are easily behind bronies, furries, commies, and kitty diddlers for worst people on the planet. You're assuming that many lawyers are not themselves bronies, furries, commies, and kitty diddlers. Remember who you're talking about. These Hands says, is going after a lawyer who has an ongoing case because you don't like their client as another lawyer an ethics violation? If so, can you be disbarred for it? It would be tough. It'd be tough to disbar someone or even discipline them because we do have free speech, right? We do have free speech. It's probably not an ethics violation so long as you're not doing anything unethical in the commencement of that. Dave Youngson says, aren't public figure doctrines unconstitutional as the First Amendment states? People should not be restrained from applying to the legislature for redress of their grievances. Isn't holding someone to a stricter standard for defamation just that? That's an argument. That's an argument, but the Supreme Court has routinely denied that argument. Although, and again, this has a lot to do with how communication has changed and how the law lags behind it. Social media, some people suggest that everyone with a blue check should be a public figure, right? Their verified account, given that verified status because of their public presence. So some people suggest that any blue check's a public figure under the existing interpretation of the public figure doctrine. That's not the worst argument. And if I were opposed to Vic, I would certainly use that in my argument. I would use the size of his Twitter. I would use the blue check mark verification status. I would use the fact that he, you know, is an actor, that he has appeared on screen in saying that he is a public figure. Opposed to that, I would say, well, he's an actor, but voice actors aren't real actors anyway. They're just pretend actors. No one recognizes his face outside of a limited subset of the population who not only are anime fans, but are anime fans to the point that they know who voice actors are. I would cite a whole bunch of people. I would actually cite a bunch of Twitter lawyers out there right now saying there's one today saying a week ago, without this lawsuit, I wouldn't have known who this person was or any of his gross actions towards women. So you can just go ahead and assume. You can assume a lot about the opposing attorneys, but you know, that's up to y'all. Whatever assumptions you need to make on that. But yeah, well, if you wouldn't have known about him, how are you going to make the argument that he's so pervasively famous that the judge doesn't know what he looks like, the opposing counsel can't pronounce his name right, and people all over the internet are saying Vic who? You wouldn't find too many people on the internet saying Dwayne "The Rock" Johnson who, Michael Jackson who, right? Johnny Depp who, Robert Downey Jr. But you'll find a lot of people who don't know who Vic is, right? So those are arguments for and against. there's a very real possibility that the court finds that Vic is a public figure or a limited purpose public figure. We'll see. This does not defeat the case. It makes it more difficult to show malice, but there are lots of ways to show malice. And yeah, those we'll see what's coming. We'll see what's coming. How about a reporter that specializes in anime that mistook his voice for another actor? Yeah, any of that stuff would be you'd want to introduce as many of those things as possible and say, look, this is a medium that people do not see. That people do not see the person who is behind the character. They see the character more often than they see the person. That's the type of argument you'd make. But again, it's an argument. It's back and forth, and they'll have to determine that. They'll have to determine that at trial. Yeah, the Star Trek fan thing is out there as well, but that doesn't. It's a Star Trek. It's a specific subculture fan production. Yeah. William Shatner or Vic Mignogna, who can 9 out of 10 people pick out of a lineup, right? William Shatner. They just can. Snowbird says, happy birthday to me. Hey, happy birthday. First super chat, I appreciate your insight into the various cases you cover, particularly this Vic one. You and Ty are awesome. Thanks for your hard work. Hey, thank you. I really appreciate that. I really appreciate that. All right, let's hit this document. It is 6 pages. This will not take too terribly long. Comes now. Defendant Funimation Productions, LLC. Defendant or Funimation, and files this original answer, verified denial, and affirmative defenses to plaintiff's original petition would respectfully show the court as follows. 1. General denial. Notice they do not open with a giant fact section full of defamatory statements. Defendant generally denies each and every allegation contained in plaintiff's original petition as authorized by Rule 92 of the Texas Rules of Civil Procedure and demands strict proof thereof. Well, there you go. Verified denial. Defendant specifically denies plaintiff's allegation that all conditions precedent have been performed or have occurred. Defendant specifically denies that plaintiff complied with the requirements of the Defamation Mitigation Act before filing this lawsuit. Now, I have seen some hubbub over this because of the there was some people asking if a TDMA letter had been sent to Funimation. Yes, one had been sent to Funimation. Defendant specifically denies that plaintiff's purported request to defendant complied with the requirements set forth in 73.055D, the Texas Civil Practice and Remedies Code. Plaintiff's request failed to describe all of the allegedly false and defamatory statements by defendant and state the time and place of their publication, if known. I mean, that's interesting. Instead, plaintiff refers to unspecified tweets from other voice actors. I can tell you they actually refer to specifically the tweets from Funimation. But again, you have to put out the defense, even if the defense isn't complete, right? Like, you have to assert the defense or else you might lose it. So without identifying the substance of the tweets and the time and place of their publication. Plaintiff also alleges that the, quote, implication of Funimation's tweets is that plaintiff engaged in sexual harassment or sexually threatening behavior when the referenced Funimation tweets do not use the word sexual or refer specifically to any threatening or harassing behavior by plaintiff. This is what we were talking about before, the substantial truth of the publication. The substantial truth test will basically show that does the omission of specific facts lead a reasonable person to an inference that is defamatory? I would suggest yes. Yes, that it absolutely does. I don't know how you read the 3 tweets of Funimation about Vic Mignogna that were not necessary to be made as anything other than suggesting that he was engaged in some sort of harassment. And the implication is, of course, sexual harassment. But we'll see. Even if it's harassment, even if it's just harassment, that would be defamatory, right? So affirmative defenses. Defendant is not liable to plaintiff because plaintiff's own acts or omissions proximately caused or contributed to plaintiff's injuries. So, of course, it's Vic's fault. That's the affirmative defense. And now, remember, the way affirmative defenses works, again, if you fail to plead an affirmative defense, you lose the opportunity to raise that affirmative defense at trial. So they are pleading the affirmative defenses, even if they may not necessarily apply. But you got to plead them just in case they do. Because if you win on an affirmative defense, you win. Defendant is not liable to plaintiff because defendant's allegedly defamatory statements were substantially true. Defendant, so that's where they would say that they're substantially true. Although this obviously conflicts with the implications of this stuff here, but you can have conflicting defenses. That's okay. Defendant is not liable to plaintiff because plaintiff and or his agents consented to and or published the allegedly defamatory statements by discussing them in public and on social media outlets. Well, we'll see about that. Vic made 2 statements and does not actually, I don't believe, discuss the harassment in any sort of way. So Funimation there is defending against statements purportedly made by its agents, I would be guessing. Defendant is not liable to plaintiff because of plaintiff's previously diminished reputation. That's a hard pill to swallow. That's a hard pill to swallow. A defendant is not liable to plaintiff on the grounds that defendant was induced and provoked to make the statements by the wrongful and malicious acts of plaintiff. That's interesting. So they're going to say that they had to make these statements. They had to because Vic was just so bad that they had to make them, even though they waited several days and Vic didn't do anything to provoke it. So that's weird. Defendant is not liable to plaintiff for allegedly defamatory made by third parties, including any allegedly defamatory statements made by any other defendant sued in this lawsuit, because those other defendants were not agents or employees of defendant and therefore were not acting within the course and scope of any agency or employment. This is, I think, again, the agency aspect of these people were representing themselves as having knowledge specifically of information related directly to their employment with Funimation. They say that pretty specifically. Toye and Monica specifically state that they were part of the investigation, that they know specifically about the investigation, that they know this stuff is occurring. Toye does it in the tweets or in the text messages to Kamea-kan, all of that stuff. Defendant is not liable to plaintiff because the allegedly defamatory statements were not made with actual malice. Maybe. Except if they made the statements, Funimation would definitely have made them knowing their falsity. Like if they are defamatory statements, in Funimation's case, if you can show defamation of the if you can show that the substantial truth of their tweets leads to a defamatory result, right? So if you can say that any reasonable person reading this string of tweets says, following an investigation, Vic Mignogna is terminated. We do not condone harassment of any kind. So if you take those 3 statements and go, Vic Mignogna was investigated for harassment and found to be harassing, if they make those statements then and say, well, we didn't actually mean it that way. They're clearly made with malice, right? Because the actual malice, legal malice, is knowledge of the falsity or reckless disregard for the truth. So if those statements are defamatory, they would have known they were false. They're the party who did the investigation. So of course they would be made maliciously. It's a weird circular sort of argument, but if it's a first party statement about the first party's investigation, then you'd think they would know the outcome of the investigation and therefore would be defaming him maliciously. Defendant is not liable to plaintiff because any alleged defamatory statements were statements of opinion. That's a weird one. Defendant is not liable to plaintiff because plaintiff does not identify a valid contract that was the subject of any alleged interference. Sure they don't. Defendant is not liable to plaintiff because plaintiff waived or otherwise forfeited any contractual rights he claims to have had through plaintiff's own conduct. Defendant is not liable to plaintiff because plaintiff is libel proof. This is like the least likely one. Being libel proof means that your reputation is so bad. It is so bad that people can't make it worse. At the time of the statements, Vic wasn't even close to that. And y'all support. Here's a cool thing for you guys. Here's a cool thing for you guys out there in the internet land who are fans of Vic and fans of anime. You guys have largely defeated this argument, hands down, because they can show that Vic's reputation is not so thoroughly damaged that people don't show up, right? He has been booked to a couple conventions. He has been booked to a couple appearances, well, at least one appearance outside of conventions. And when every convention he's gone to has had lines out the door. So if you're going to tell me that his reputation is so bad that it can't be worsened, you're going to have a hard argument there. And that is credit to y'all, right? Supporting him online, supporting him from the get-go. Even before I was involved, people were still supporting Vic online. The Rise and Bull Rangers were supporting Vic online. They did not just immediately turn on him. If his reputation were irreparably damaged, nothing anyone said would have helped, right? People wouldn't show up. He wouldn't be at any conventions, but he's not. And so that's a credit to y'all. Good job. Good job on doing that. If defendant is found liable for damage, defendants intend to seek a reduction of damages under the proportionate responsibility statute, including any credits for a settling person. So yes, if any of the other parties do settle out, they would get some credit for that settlement amount. Plaintiff is not entitled to exemplary damages in regard to any defamation claim which plaintiff failed to timely serve a request for correction, retraction, or clarification within 90 days after learning of the publication of the alleged defamatory statement. If defendant is found liable for exemplary damages, those damages must be capped under Texas Damages Act, Due Process Clause of the United States Constitution, and the due course of law provisions of the Texas Constitution. And then defendant demands a jury trial and tenders the appropriate fee with this answer. Request for disclosure. Under Texas Rule of Civil Procedure 194, defendant requests that plaintiff disclose within 30 days of service of this request the information or material described in Rule 194.2, which is general discovery material. I think we discussed that in a previous stream. So this is signed by John Volney of Lynn Pinker Cox and Hurst. And Rebecca Lynn Adams as well. Or Rebecca L. Adams. I shouldn't say Lynn Adams. My brain just went L and Lynn. Rebecca L. Adams. So those are the attorneys. These are outside counsel for Funimation. Obviously, they do have in-house counsel of Evan Stone, but he is not on this document. He may still be working the case. Haven't seen anything to confirm or deny that. So here's the verification. Oh, Evan Stone verified it. This is weird. Before me, the undersigned notary. Oh, so he just notary. No, wait. No, there's a notary. On this day, personally appeared Evan Stone, the affiant, whose identity is known to me. After I administered an oath, affiant testified as follows. My name is Evan Stone. I am capable of making this verification. So this is interesting. So this is Evan Stone. He signed the verification, which means he's not representing Funimation, but he is admitting that he is a witness. Evan Stone can be called as a witness. That's an interesting play to have Evan verify this, because Evan can now be theoretically deposed, examined and cross-examined. So there you go. Evan Stone is a witness rather than counsel for the party. So then the certificate of service, you have to serve it to attorneys of record. And Jamie Markey's attorney is not actually recorded on the e-filing service. That's why he's not included here. I don't know why that is, because he has theoretically appeared before the court. He served an answer, and he filed and served an answer. So I'm not sure why he's not listed as an attorney of record, but because he's not on there, presumably he's not required to be served yet. So there you go. That's the gist of this That's the gist of this document. Like I said, it's very straightforward. Again, Monica and Ron Toye's answer is a weird filing, very ugly, way outside of the requirements of Texas law. It includes a bunch of defamation and statements that are unnecessary and may even be prejudicial. So it's very, very strange to do that. Whereas there are some other problems with Casey's filing that we haven't discussed as well. There's also, but Monica, or not Monica, Jamie Markey and Funimation have filed concise notice pleading answers that are sufficient. They contain general denials. They lay out their verified denials and affirmative defenses. They make perfect sense that they would plead these. They don't seem overwrought, and they seem just fine. So these are good. They don't give us too much more indication than that. Well, Jamie Markey said that one weird affirmative defense, but that seemed like that lawyer's particular pet project to preserve the opportunity to argue that on appeal. But I don't know that, that would be the proper case, but who knows? Who knows? So there you have it, guys. There are the docs for Funimation. Their answer is, like I said, it's competent. It is reasoned. I'm surprised that there's not a TCPA filed right along with this. I'm surprised. Very, very weird because, and same with Markey's. They could absolutely file TCPA motions straight along with this. They don't have to yet. They have time to do it. But yeah. So we'll see about that when I keep expecting a TCPA to show up and one has not yet. It would be nice because getting past a TCPA would bring parties closer towards settlement talks. If they think they can win on a TCPA, they're probably not going to settle. As for depositions, I don't know. I don't know the dates of anything yet, and we'll see. We'll see what's going on with all that. So anyway, guys, let me read through the super chats, and then we'll wrap up the stream. For any of you, I know many of you do peace out during the super chats, and that is, of course, no problem with me. I read them as my personal agreement with the audience that any super chat that comes in will be read and addressed. Yes, but for those of you who do leave, thank you very much for watching. I think tomorrow, barring something weird might be a really fun stream. It might even be like a weeb stream to prepare me for what I'm going to witness at Anime Matsuri. I will let you know as soon as possible. Kind of scrambling on the home front, along with the YouTube front, getting things ready for me to be gone for several days. So there you go. That's that. Let's hit these super chats. Jordan Rhodes says, sipping some Irish whiskey. Have this free $1.99. Hey, thanks, buddy. Kakalo Tuzaru says, I can finally catch one stream live, even though the reason is I can't sleep due to muscular stiffness in my arms. Ouch. That sucks. Andrew War Snowboard says, this is reality, not Twitter, you giant idiot. Ryu Sketches says, hi, Nick. A KickVic user who goes by Terez27 on Twitter was linking people who don't know about the case, the IO9 article. Comment on the thread to stop misinformation spread, and the girl blocked me. Well, girl's charitable. That's charitable. Terez is garbage, so who cares? I mean, of course these people are going to spread the misinformation. Of course they are. That's how they operate, right? This was I can't express enough how many signs they've given that this was coordinated. Every step of the way, they act in concert. So, yeah, of course they're going to keep doing it because they can't not brigade someone until they're dead. So there you go. Neil Purcell says, I don't think you've ever seen Dark Queen. Wait. Oh, are you... Rude. Rude. Of course I have seen the Dark Queen. And defeated the Dark Queen. However, the new Battletoads Dark Queen looks like trash. The new Battletoads kind of looks like trash too. I'm getting more and more pissed off every time I see it. Not a big fan. Stop Collaborate says, Ricada, update the dang podcast backlog, FFS, heart you. Yeah, I'm sorry. I need to do that. McGraybush says, the Oberlin fiasco makes me glad my alma mater, University of Wyoming, didn't back down to SJWs complaining about their branding campaign. The world needs more cowboys. There's at least some integrity on campus. Sometimes. Deleted account says, talks about Arms Girl getting served for the lulz. I don't know that Arms Girl got served. She got a, you know, a couple, letters. She got some sort of letters earlier in the case. They were a while back. Tommaso Choco Taco, thank you. Deleted account says, talk about Jesse Pridemore getting papers too. Well, Jesse Pridemore is whew. Oh, you said Pride whore. We'll see. We'll see how things go for her. Alleging someone raped you who didn't is a tough one. I wonder if Twitter lawyers think that saying someone raped me specifically at a specific time and date is defamatory. That's because a lot of them seem to think that there's nothing defamatory, and it's amazing. Chaotic Rebel says, hey, Nick, hope you're having an awesome day. Today's my birthday. Hey, happy birthday. And I just want to say thank you for all you do for the nerd communities. Looking forward to the stream tonight. Well, I'm glad. Hopefully it was good. The Scott16 says, what is the legal definition of genocide? I'm asking because Justin Trudeau apparently doesn't know. I don't know what the legal definition of genocide would be. That's an interesting question. Now I'm going to have to look it up. I don't actually know the answer off the top of my head. Typically it would be, you know, the extermination of a particular race of people. That's the common definition. I don't know what the, I assume there's some sort of international compact that defines it, like the Geneva Convention or something like that. But yeah, I'd be very interested. I probably knew at one point. Malcolm says, hello, I used to live in Egan, I think you're saying. I don't know if you know where that is. I do. I'm in college for animation and was wondering what your zodiac sign was. Sagittarius. Capra Dea says, Greg is a hovercraft juice and sleeps with lines. Okay, there you go. Bagel Goose says, Cuck Lightyear suckling as many drippings of daddy's cummies as he can. Kaz Michael says, please bring Larry on for Chad Dad on Father's Day. I asked Larry already and he said he would love to come on for that. Yeah, that would be good. That'd be a good show. I should do a Chad Dad on Father's Day. When is that? That's coming up, isn't it? That's the 17th, I think. I'll have to see what's going on. That guy Mitch says, unsponsored ad. Boy, do I love Milo's sweet tea. So sweet and delicious and with no sugar. There you go. Ralph says, donating to your unemployment. Shame V2 is rapidly trying to gain relevance. Mr. Duchette is probably trying to get that new CPAP with self-cleaning. I wonder when it becomes fraudulent to keep crowdfunding something that was funded a long time ago. The Bone Zone says, Fig Exterminatus now. Ivan Feza, thanks for donation. Top Secret says, if everyone donates $5 to Vic's GoFundMe, it'll be complete. Donators will be over 9,000. Just so you guys know, there's a fan out there who has made or is almost finished, almost completed 3 Klingon style knives, 3 knives of varying sizes that we are working on. I think I've mentioned this before, but just keep in mind, we're working on some sort of auction process where we can get the knives and get the money directly to the GoFundMe. I don't know how we'll do it. Maybe we'll do something where the highest donation within a specified time period would go to the knives. Maybe we'll actually, that might be fun because then, you know, people would be donating as they go, highest cumulative donations or something. People would be donating the money as they went, and so it wouldn't just be whatever the highest 3 bids were, but that is coming. So if you're interested in that, just keep that in mind. I'm not sure how we're going to do it, but it should be fun. We're going to make it a fun event. I'm waiting for pictures of the finished products, but that is still in the works if you heard about it before. So there we go. But yes, again, please consider donating to Vic's GoFundMe if you are able to. Crow751 says Darth Vader CPAP mask. DCV Titan says a Cuck Lightyear mission patch to cuckoldry and beyond. That guy Mitch says Cuck Lightyear a Soye story. Echo the Mel, thanks for the donation. Skeet Meat says Cuck Trek the new male generation. Yes, I'm desperately pushing this. Sevic says, can enough coordinated frivolous complaints be a harassment campaign? Like legal actionable harassment? Maybe. That'd be a really hard one to do. That'd be really hard to do. Mora Djokovic says, here's to Vic. Hey, thanks, buddy. Talbot Link says, Rackets Battle Cry Malice Beat. Mr. DJ Fly High says, hey, Nick, it was my birthday on the 10th of June. What's your thoughts on E3 so far? I haven't really been watching that much, but like a mobile Commander Keen game is something no one asked for that I can imagine. Mobile games can die in a fire. I'm sorry. They're never good. I know they're super profitable for companies, but they just suck. They just suck. No, I don't want them. Now, a mobile game on something like a Switch or a game console, it's fine. It's fine. Or, but like on my phone, I don't like phone games. I just don't. Even when I get some entertainment out of them, I'm done in like 5 days. Never want to see it again. So otherwise, my thoughts on E3 are not great. I don't care about Fallout 76. I'm interested in Project Scarlet, the Xbox with ray tracing and stuff. I thought that was supposed to be 3rd quarter this year or 4th quarter this year, but it looks like it's going to be next year. Yeah, Project Scarlet looks interesting. I'm interested in AMD versus Intel. But as far as the games, I'm just not that into what I've seen so far. And Battletoads, again, just looks like trash. Also, what are your thoughts on the Google lawsuit now? It's very interesting. The Google lawsuit is persisting through Discovery. And if I had to guess, Discovery was the ultimate target of the Google lawsuit. And I'll be very interested to see if Google decides to attempt a settlement of the class now that they're going to Discovery, because Discovery and disclosure, especially of internal Google communications about conservatives and Republicans and Trump, that could be really, really ugly for the company. Jack Straw says, link Meyer's GoFundMe. How is Meyer's GoFundMe? I can do that. GoFundMe. Here we go. Meyer's GoFundMe is at 128,200. So it's doing great. Still, if you guys like Zach, support him. He's a good dude. In a nasty situation, has to pay a lot of money for legal fees. I have linked it in the description. If any of my moderators want to repost that, please feel free to go ahead. But there you go. Arturo Martinez says, thank you for helping me with my English. Your channel has helped me more than ever. God bless. You are amazing. Hey, thanks, buddy. I really appreciate that. Sergeant F off says, is BuzzFeed lawyer Heather S? No, BuzzFeed lawyer is not Heather S. Lord Sinch says, do not worry. This lawsuit is going according to plan. I don't trust it now. Now I don't trust it. K9 Affirmative says, take Google's money for me. I will. DNA Crows. Thanks, buddy. Inatrev Hoskins says, hey, Nicky boy, I love what you were doing for Vic, but I wanted to see if you ever looked into the Stephen Avery case. to see how good or bad it was put together. Keep up the good work, my good sir. I've not had time to watch a documentary about that. I'm interested in doing it. I just don't have time. Mike Lombardo says, forgive me if I misremember, but didn't Meyer use the video from the con Waid went to in Texas when he defamed Meyer? He didn't. I don't think he did in his initial complaint. I think that was referenced in the discovery or in the jurisdictional argument. I don't think it was in the complaint. So we'll have to see. Blaine 20 says, just to hammer home the point to certain false accusers, Galen Dunn confirmed days ago that the pictures of Vic and two ladies was in fact Photoshop Malice B. Well, I have not commented on that because I am not in any way qualified to talk about whether or not those pictures are photoshopped. But yeah, if you guys want to check out Galen Dunn at Hammermore on Twitter, if you want to check out his analysis and you know, make of it what you will. Again, I can't personally put forth those sort of things because I can't verify them. I'm not qualified to do so. So you guys can check that out if you want. Imals Katuli 2016 says, hey Rackets, don't forget the gunsling. Ah, dang it. Yeah, when I start playing the whatchamacallit, the outro song, I'll leave the video on, I'll run up and grab it and run back downstairs. Timothy Reaper says, Nick's persona is an interfering tortoise. Blaine 20 says, I hope Ty likes his new Yamato present. Bug him for pictures for me when he finds a place for it. Will do, buddy. Ranstein Hernandez says, back in February, Monica commented on one of your earlier streams, Funimation will protect me. She deleted it seconds later. 100% sure a few people saw that too. I can't prove it though. Well, yeah, they were kind of, early on, I think they were thinking about Funimation stepping in for them. Very, very short-sightedly thinking that. I think they may have all gotten an understanding of how much they mean to Funimation at that moment. Finn Frog says, good night, y'all. Zan VT or YT says, can't wait to see you and Vic at Anime Matsuri. Hey, me back at you, buddy. SM Skorks 89 says, wasn't Casey, Eric, or Moron supposed to hand over Discovery materials today? It was their deadline. It was their deadline. Do you know if they did? I do not. I could not get a confirm or deny out of Ty today. He was very, very busy. How bad is it if they didn't? It varies by the type of discovery. They could have motions to compel. If there were requests for admissions, they could be automatically presumed to be true. We'll have to see what happens on that. Puppet McPuppetface says, watch Sarah Zanami. There you go. Pro Hero All Might says, hope you play and stream the new Battletoads. Ugh. Sound of One Hand Clapping says, met Todd at SAC Anime. He said a SmackDown's coming. Well, good. Good. False rape accusations. I mean, we can not let these keep happening. Can't do it. It's crazy. It's crazy that we do. Might want to remove the document from the screen. Why? Oh, just because? Okay, here. That's a good idea. We'll switch back over here. Blaine 20 says, FF7 teasers keep looking better and better. Summon sequences will cause rampant cardiac arrest, especially Bama and Knights of the Round. Is Knights of the Round still 12 minutes long? Gladiator says, please don't bring Corey on the Weeb stream. He sucks. Aww. Aww. Corey. From Anime Outsiders? We'll see. Richard G says, once the lawsuit is over, I'm hoping for a book of all the great ricatism and ricatatisms and beardisms that have been spoken. Devil Hunter Nero says, is there a possible GoFundMe stream with I Stand with Vic? I don't know. Again, I don't know specifically how to do that because we can't direct the chats to it. And it's hard to keep track of the comments that come in real time that are attached donations, but maybe. Yeah, maybe. Gawker's Death Rattle says, ahem, Pokemon was a mobile game, sir. Well, and you can like it all you want. Not a big fan. I'm not a big fan. Do people still play Pokemon Go? John Sargent says, just seen an interesting chat. Screenshot in DM. What? This. Oh, yeah. Yeah, I think I don't think it's what you think it is, but that's fine. Thanks for letting me know. Jokin, thank you for the donation. Raider J says, look up Phoenix Wright, Smooth Criminal. Notorious Moonman says, tell the people in your Discord to embrace chaos. Hey, people in the Discord, I guess embrace chaos. And then finally, Blaine20 said, need professional advice. Should I start playing Final Fantasy VII on Switch now or wait for the remake? Ooh, that's a good one. Depends how much you like Final Fantasy VII. Why not both? Mr. DJ Fly High says in the rock voice, you smell what the rackets is cooking. That's probably a bad rock voice, but Dirk Lemon says, why are people so obsessed with Final Fantasy? How many times can the same game be remade with slightly different graphics? Final Fantasy sucks. Whoa. Strong words. Strong words. There you go. Bagel Goose says, Nick, show your feet. I will not. However, let me go ahead. Let me go ahead and start the outro music. I will run up and grab the gunsling from Emmaus and show that off, because it is really cool and I really do like it. I just keep it's upstairs. Cloudfire181 says, hey Nick, on a stream as a side project, would you go over Legal Eagle's arguments on why Captain Marvel is allowed to threat a man to death for hitting on her? Sounded like something Shane would try to bring up as a defense. Maybe we'll do that sometime. I won't play the video on the stream because I don't want a bogus copyright claim. All right, so here is the outro. Just a second. Please enjoy the lovely sounds of the whiskey drinking lawyer for just a moment. I will be right back. I'll be right back.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along with his glass by his side and his kids asleep tight. We'll hear some lawsplaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. All
right. Here we go. This is the Paracord Gunsling sent by Emmaus Cthulhu. This is cool. I may have to crowdfund some scuba equipment so I can get to the bottom of the lake and retrieve the armaments that this would be attached to. But I really do like it. I think this thing is made entirely of paracord, which is crazy. Let me see if I can get you the braiding. You can see it's braided underneath. It's crisscross up top. This thing is very cool. I really do appreciate it. Thank you so much. Before it fell in the lake, I did not have a strap for the AR, so that is very, very helpful. Plug the band behind the song. Well, it's in the descriptions. It's My Room Records. I don't know if he's a band or if he's just one guy. Well, I mean, I know the answer to that, but I don't know if with this song, if he's representing himself as a band or just one guy. But My Room Records, it's on SoundCloud. The link is in the description. So if you like it, you can go check him out there. He has other songs as well. All right, guys. Thank you. Thank you so much for the stream tonight, for hanging out with me. Bagel Goose says, "Gimme them toes, macaw." Oh, and Dave Youngson says, "New Prime Inc. versus Oliveira may have caused funny damage, as they have said that the term employee should be interpreted in the way it was used when the law or statute was written. So Monica and Mars Girl could still be classed as employees." Well, I'll have to check it out. And then Super Alfredo 64 says starts a mosh pit with this song, aka Hit Me. All right, guys. Well, I'm gonna go and rest my voice and my eyes. Still trying to catch up on sleep from the other night, and we will talk to you guys soon. I will announce the stream tomorrow and what it will be as soon as possible. It entirely depends on what if I find any more information out about the Vic case. But I would love going into Anime Matsuri to do just a fun stream. I've got some applications for the Weeb stream that are not people who have been on before, and that might be fun to get some fresh perspective. And Blaine20 says shout out of love to Meadow Kitty. So there you go. All right, I talked so long the outro finished. Oh my goodness. All right, guys, I'll run it again as I blank the screen, just for completeness. Okay, guys, I'm gonna go. Peace out. I'll talk to y'all tomorrow. Bye.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lawsplaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lawsplaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out a glass for the tea post on Twitter as we hear lawsplaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than